Hi, everyone. My name is Danielle DeSpirito. I'm a 3L at Pitt Law, and I'm here today with Professor Carter, who is a professor at the law school. Hi, Professor
Hello,
Carter. How are you doing
everyone.
today?
I'm good. How are you doing, Danielle?
Good.
Good.
Obviously, we're a little different here on a Zoom rather than in person, given the pandemic and everything we've had to adjust. So we thought it'd be a fun way to go on Zoom, record our call, and then have a little Pitt vlog about it.
Sure.
I wanted to first start by thanking you for taking the time to meet with me today, and allow the students to hear a little bit more about you. I was thinking we could start by you talking about your background, maybe your experience at Pitt Law, and some of the research or recent publications you've done.
Sure. Yeah, happy to. And thanks to you for taking the time. I know in a leadership role, particularly during a difficult academic year, to say the least, that you have very little spare time. So thanks for taking it on. So just a very brief background regarding me. So I went to law school at Case Western, and when I graduated, I moved down to Washington, D.C. and worked with a couple of big law firms, which was not my initial ambition. I initially wanted to do civil rights or public interest work, but for a variety of reasons, my first job ended up being with a couple of law firms, and honestly had a great experience in a lot of different ways. I was not actually looking to leave practice and go into academia. Quite honestly, that never occurred to me. Becoming a law professor was not like on my list of career ambitions. It just so happened that I had a prior interest in education because my undergraduate background was in secondary education. And of course, had always had an interest, in thinking about ways to use the law and to teach the law, but I never thought about combining them into a full-time job. And I just got very lucky and started teaching back at my alma mater at Case Western a few years after I'd been out in practice. And while I was there, I taught civil procedure, constitutional law, and subjects in international human rights law as well. I was there for about 6 years and then went to Temple Law School, had the opportunity to go to the faculty there. I was there for about 5 years teaching the same subjects and came here to Pitt Law in 2012 as dean. So I was thinking about this the other day. This is now my 8th year here in Pittsburgh, which seems bizarre. It seems like it was just yesterday. So for my first 6 years, I served as dean of the law school and then decided that someone else could have that pleasure of that leadership position. So a couple of years ago, I just rotated back to being on the regular faculty, which has been great. In terms of my research areas, there are three primary areas that I've written in over the years. The first and largest is the area of race in the law generally, and the 13th Amendment specifically. We can chat about that if you want. The second is with regard to international law and international human rights. And the third area has been criminal law and criminal procedure. But I'd say most of my research these days focuses on race in the law, constitutional history, and specifically the 13th Amendment.
Some might say you've come to the better half of the state by leaving Temple and coming to Pittsburgh.
I've heard people say that, and people on the other half say the same thing about
Right,
y'all.
as to
So,
say,
mutual.
I'm lived and stayed in Philly for about 6 years, so I feel
Okay.
the pool of Philly versus Pittsburgh, and the whole
Yeah.
sports scene and everything like
Yeah.
that too. So
Yeah. Yeah.
I don't know if
But
I would
it's
necessarily say you came to the better half, but I love
yeah.
Pittsburgh, so it's a
Yeah, it's
great
been good,
place.
honestly. I mean, they're two very different cities, as you know,
Yeah,
but I've enjoyed them both for different reasons. I've enjoyed them both a lot. And
yeah.
Pittsburgh's been very good to me.
Yeah, right. I can't complain. It's been very
Yeah.
great. I could complain a little bit about the rain sometimes, but that's
Yeah.
just something.
Yeah. There is that.
But
Yeah.
we've definitely lucked out this year too with the weather.
Yeah.
So,
Yeah. That's right.
so you were able to translate a lot of your research into some of the classes you teach at Pitt Law, right? So what kind of classes do you teach, and maybe what ones do you enjoy or look forward to every year?
Yeah, so it's interesting. I would say you're right that some of my areas of research have become classes. I'll talk about that in a minute. But it's also the case that some of my classes and my dialogue with students have become research projects. So a lot of my ideas are sparked as I'm grappling with the cases with students, right? And we'll talk about areas that are unclear or ambiguous or seem inconsistent, and they'll just kind of spark something, and I'll think, that could be an interesting article that I could write. So On the one hand, I would say in terms of my research interest in the current classes that I'm teaching, my seminar in the law of slavery, abolition, and freedom grows directly out of my research areas. So I developed that course a couple of years ago, and the Dean's office was kind enough to add it to the curriculum. I've also taught courses, although I'm not teaching them currently, in critical race theory, race in the law, equal protection, again, all areas that have come out of my research. But the converse has also been true. So my bread and butter courses are constitutional law and civil procedure, two of the 1L courses. And a lot of my article ideas have come out of that. So my most recent article, one of the ones I'll be talking about during Constitution Day, is about freedom of speech and slavery. And in fact, the spark for that came out of the First Amendment unit that I taught and teach in con law, and began thinking about the different ways in which the Constitution has protected certain rights differently for different groups at different times, which then kind of prompted me to think more deeply about the First Amendment, but also about how it related to the law of slavery. And that's one of the great things about being a professor. You have a lot of intellectual freedom, and you get the opportunity in your research to explore what makes you intellectually curious. And hopefully, at least some of your courses also end up being in your research areas as well.
I think that's something really nice too that Pitt Law offers, is that there is that real world type research that you can bring into the classroom rather than just having, your basic, like you said, constitutional law, civil procedure type classes. And I think that as an upper level student, it's something that you really value, because you get to see, what do I want to do when I leave these, these doors of Barco or whatever your law school experience is, like, what do I want to do, or where do I think my time is most valuable spent? And it's nice that you get to experience some of that in law school, and take classes that, and I know you said your Law of Slavery, Abolition, and Freedom seminar, that's a seminar, so that counts for the upper level writing for some students, which is really nice too.
Yeah.
That people get to get really deep in a 30-page minimum paper about something they're probably really interested in. So I think that's really cool.
Yeah, no, and I think, law school is an interesting graduate school in that it's like half professional school in the same sense as dental school, right? But also kind of half law history philosophy, right? And kind of finding the right balance as a student, depends on the student's individual goals. But as you said, you at least have the opportunity to take things that are very practically oriented, civil procedure, trial tactics, corporations, as part of the same education, where you get to take things that are more kind of your passion areas, even if they don't directly translate into the kind of law that you hope to practice.
When you come in as a 1L, you think, wow, here's 3 years. This might be the longest 3 years of my life, or the shortest 3 years of my life. And now I'm, starting, well, I guess we're 2 weeks into my first semester 3L year. Yeah. And I'm thinking, oh my gosh, I didn't get to take half the classes I wanted to take. There's so many areas of interest, and something that's great about Pitt Law too is that we just have so many faculty and staff and professors that are just so interested in like a wide array of things that when it comes time to make your schedule, you're like, I don't have time for all these things, and I want to.
I can't take 40 credits per semester. Even in the classes that are more doctrinal and quote unquote practically oriented, the law is influenced by kind of social forces and individual as well as government level decisions in ways that aren't always transparent if you're just looking at the surface of the case, right? So one thing I try to do in Civ Pro and Con Law is to bring in those critical perspectives, that may be under the hood, and those things do become relevant in the actual practice of law, right? If you're dealing with clients, you're dealing with not just an abstract legal problem, you're dealing with a person, right? The person as a whole. And that person has experiences that may be related to their identity or to poverty or to background or to nationality that help inform, I think, the way that you deal with the client as a person. And so I do think that it's great that, pretty much every one of my colleagues that I know tries to interject those outside the case book matters as they are relevant to understanding the doctrine.
was there any particular work, whether it be like your research, a book, chapter, a publication, presentation, anything like that, that you either were most proud of or most excited about? It could even be your class too, because I know that's probably like, if you created some of your classes and your seminars, that's also something that you could be very proud of, that you're, introducing to, 15 or 20 students.
One of my articles about the 13th Amendment and caste, that is how sometimes racial discrimination can become so fixed that it's almost like an unbreakable caste system, was cited by the NAACP Legal Defense Fund in one of their briefs in the Gravin Gim transgender rights bathroom access case. My article had nothing to do with that particular topic, right? But they found the framing and understanding of subordination through the lens of the 13th Amendment to be something that translated, into real world litigation that hopefully, had some positive impact. So that's kind of one thing I think about. It's not so much that the work itself was spectacular. I mean, it was fine. It was good. The article is fine. But it was more that it added some knowledge of value that had some meaning to someone outside the walls of academia, in addition to whatever meaning it might have inside the walls of academia. One of my former students at Case Western, who had taken several of my classes, when he was graduating and getting married, he asked me to serve as the officiant at his wedding. Right, because he had thought that the classes and the relationship that we had as a teacher and student was sufficiently meaningful to him that he wanted me involved in that part of his life outside the classroom. Or when students say, thanks for interjecting that perspective, or for covering this material in class, because I knew there was always something about this area of law that bothered me, but I didn't know what it was, and now it's kind of given me some inspiration to think about it a little bit more. So it's kind of more those moments, rather than particular articles or particular classes that I guess show that you're having some impact.
Next week, we're having a Constitution Day celebration, and you're going to be our keynote speaker. I was hoping maybe you could give us a little preview of the event, or just what we could look forward to hearing from you during.
Yeah, sure. So, as you know, Constitution Day is federally required that institutions of higher education have a day where they focus on constitutional issues. And the University of Pittsburgh has asked the law school each year to take the lead in planning that. So this year, Associate Dean Brake asked me to serve as the speaker for Constitution Day. And I said, sure, I was happy to do it. But I didn't want to do it in the traditional kind of talking head, droning on and on and on format for a few reasons. One, that's a lot harder to absorb when you're looking at a screen all day, right? So I figured people would be pretty tired of staring at screens. But also because I wanted it to be kind of more of a dialogue and less of a lecture. Like even I get tired of hearing myself talk at some point. So the way we set it up is a little different than most kind of formal lectures. We will be talking about my areas of research, and I'll provide kind of opening remarks and context. But it's actually going to be a conversation between me, Professor David Harris, and Professor Jalila Jefferson Bullock, who's visiting with us this year, because both of their areas of research also touch on race and the law. So I am just as interested to get their perspectives on these issues as, to convey my own. In terms of what I plan to focus on, I was asked to talk about two of my articles that I guess kind of span a spectrum of my writing about race and the law. So the first one is called A 13th Amendment Framework for Combating Racial Profiling. And that one, I think, was published maybe in 2004, 2005. It was one of my first big articles. And that one looks at the issue of racial profiling through the lens of the 13th Amendment and through a lesser known aspect of the 13th Amendment, that it prohibited not only literal slavery, but also what its framers called the badges and incidents of slavery. Those modern day conditions that are a legacy of slavery, or that were an outgrowth of it. And so in that article, I argue that a wide-scale system of criminal suspicion based upon skin color is a badge or incident of slavery, because it mirrors, even if not driven by the same purpose, the kind of racialized control over autonomy and freedom of movement that Black slaves as well as all free Blacks were subject to during slavery. So I'll talk a little bit about that one piece, and I know that David and Jalila will have a lot to contribute there because of their own work about race and the criminal law. The other piece is much more recent. In fact, it's still a draft. It's been accepted by the Texas Law Review, but hasn't been published yet. It'll come out next year. And it's about freedom of speech and slavery. So the idea of that one, again, kind of drawing on the legal history of slavery, is that, in my view, as well as in the view of many other scholars, we have two distinct constitutional regimes. There's the framing to Civil War regime, right, the 1787 to 1865 Constitution, which I'll call the original founding. And then there's what's referred to as the second founding, the post-Civil War constitutional amendments, as well as federal civil rights statutes, that the people at the time who adopted them thought of as representing a second American Revolution, a second founding of the nation, in turning away from a society based on racial slavery to one who, at least in its fundamental charter, would be based upon freedom and equality for all persons, not merely a subset. In constitutional doctrine, as you'll recall, the cases, and indeed I would say probably most professors, spend very little time talking about the second founding as a new constitutional moment. We talk a lot about specific provisions from the post-Civil War Constitution, right? So you spend a ton of time on equal protection, due process, privileges and immunities, etc. But in general, when we talk about the pre-Civil War Constitution, we tend to act as if the second founding moment never happened. For purposes of this paper, I contend that courts tend to act as if what freedom of speech meant in 1791 when the Bill of Rights was ratified is exactly the same thing from an original meaning perspective as what it should mean today. And my point is actually not so much to kind of claim or disclaim originalism. It is simply, if you're going to analyze the Constitution from an originalist perspective, there is another originalist moment where the original framers' view was modified, elaborated upon, and in some cases rejected by the second framing. And so the article, in one sense, is kind of a theoretical plea that we take the post-Civil War Constitution seriously as a second founding moment. The second, more specific part is, if you accept that frame, which certainly not everyone would, what might it mean for how we interpret some specific constitutional provisions? And one of those is the First Amendment. So the, I think, kind of most novel contribution that the article makes is that it looks at freedom of speech, not just through the lens of the first founding's framers, nor exclusively through the lens of the second founding's framers, but actually foregrounds the views of enslaved persons themselves and asks, what did freedom of speech mean for them in a condition of slavery? What denial of their free speech rights did they experience? What would they have hoped or expected the post-Civil War vision of freedom of speech to entail? And I argue that as part of the constitutional polity that would help us understand the general public meaning of freedom of speech under the post-Civil War Constitution, that the voices of enslaved persons have been almost entirely ignored in constitutional interpretation. So I draw from a lot of first-person slave narratives, where the slaves talk about their experiences with being denied freedom of speech and talk about what they think it should mean under the reconstructed Constitution. So I'll be talking about those in the talk, and hopefully folks will find it interesting. But I think what all of my 13th Amendment work, including this most recent piece, are trying to do is to show there is a different constitutional legal history that has largely remained untold, right? That particularly the post-Civil War Constitution was one that was about equal dignity and equal worth and about freedom and liberty in many aspects. Some of them were liberty of body and movement, which is the racial profiling piece. Some of them are liberty of mind and conscience, right, which is the First Amendment piece. But the animating impulse is the same, that, there's a long debate about whether our Constitution was originally pro-slavery or anti-slavery. And my point, I guess, the intervention I make in my work is that in seeking to answer that question, we have to look at our Constitution as a whole. And too often our courts and lawyers act as if the post-Civil War Constitution didn't really happen.
I loved listening to that because it sounds very interesting, and I'm very impressed by just everything that you just explained. I think that this is going to be a very great event, not only informative, but also entertaining to listen to as well, to hear how you've developed that and the ideas that drive you as a professor and a researcher come to light as a keynote speaker and as a event. I'm excited to attend. I know that. I'm also very excited for you to be published. And you said Texas Law Review, right?
Yeah.
But that won't be till next year.
Spring 2021. Yeah.
Spring 2020. Awesome.
Yeah.
Is there anything that you're really hoping that the students take away from this, or faculty, anyone that's listening, that they could take away and have that as a memorable piece from this event?
Yeah, I was just talking with a student in my seminar today about this. So I would say this, hopefully the details of, whether it's my racial profiling article or the First Amendment article are helpful in trying to advance and illuminate legal doctrine, right? In ways that I at least think will advance liberty and equality. But from a bigger picture perspective, what I would hope listeners would take away is this. The Constitution embodies a series of choices as we translate it into real world cases. So there's the choice of your interpretive method, right? Originalism versus living constitutionalism. There's the choice of the sources you look at. Do you only look at the 1787, 1791 Constitution's original intent if you're going to do originalism? Or do you, like I contend, look to this additional founding moment to help inform constitutional meaning? Do you read the Constitution kind of to the fullest extent possible within reason as a legal document, or do you read it in its narrower sense? If you are legislators or policymakers and you're given a power by the Constitution, do you exercise that power at all? Do you exercise it to its fullest extent? And in whose favor do you exercise it? And I could go on, but my point is this. The Constitution is a document. It is a legal document that, at least in discrete areas, has a discernible meaning. But once you get beyond those particular areas where the black letter meaning is clear, we are making a series of choices to imbue meaning into this document. And what I want to make visible in part throughout all of my work is that whenever you're making choices, you can start with presumptions that operate to maximize liberty and freedom or to entrench established hierarchies. And so what I hope it sparks listeners to do in this dialogue about some of my work is to ask questions about what we consider to be the received and fixed meaning, because it's not received and fixed. It changes, it evolves, it responds to human decision-making. And so if we know, for example, that the Supreme Court state action doctrine cases generally mean that most constitutional norms don't apply to private action, we could stop there. Or we could look at the framing history of the 13th Amendment, where its framers were as concerned with private mobs denying people's rights, whether through violence or otherwise, as they were with the active suppression enforced by the state. We can do either one, right? But we need to know the entire picture to be able to make choices about what kind of constitution we, as the people who influence its application, wish to have.
Before I even asked you that question, I was thinking to myself, what is something that I could get out of the Constitution Day event? And something that I was thinking of is my lens of viewing the Constitution tends to be more of an originalist type, textualist type ideal. And I think you kind of also said this, and just what you hope students take away or listeners take away is thinking of it outside of what your original lens of viewing it is, and trying to see and hear and think of it in different ways than maybe the way that you always have. And I think that if someone, that to me sounds like a success, if at the end of the day, you can have someone think differently than they did or challenge their own thoughts about something. I think that sounds pretty successful to me.
Yeah, I hope so. I mean, I also want everybody to agree with me. Now, I
Well,
don't actually care if people agree with me. That is the least thing on my mind when I do this stuff.
yeah.
But I
No,
think
of
your point
course.
is right. One of the points of engaging in the law, whether as a student or as a layperson, is to rethink some of our prior assumptions, right? And even if we continue to hold our original perspective, it's made better by having engaged with, contrary or different approaches that we may not have considered.
Yeah, I agree. Well, thank you.
Sure.
I'll give everyone a reminder at the end of this video that the Constitution Day event is on September 17th, and it's from 12 to 2 o'clock, right? And then it's all virtual, so everyone can attend virtually. I believe it's via Zoom.
Yes, I think it'll be by Zoom, and there is a link somewhere on the event's website.
Yeah,
and Danielle will send cookies and snacks to all of your homes for watching.
Right. Hey, if I had those kind of resources, I would.
Yeah.
Well, thank you so much. I really appreciate you being here and taking the time and
thank you.
Virtually doing it as well.
Sure. Thank you, and take care.
Take care.
All right. See you soon.